this way. The criminal law world has changed. In fact, it has dramatically changed in the past 10 to 15 years. And the major reason for that change is the effect of counterterrorism law on inchoate offenses, on criminal law. And when we speak of inchoate offenses, we generally mean to the criminal attempt, the conspiracy and solicitations, and in some legal systems there are some more inchoate offenses, such as in Britain, for instance, the accessories and abettors are now considered after October 2008, after the full validation of the Serious Crime Act 2007. The accessories and the abettors are considered as inchoate offenders, although in the English common law they were not considered as such. Inchoate offenses have two main justifications. The first is that the inchoate offender is considered as not less socially dangerous than the offender who has committed the full offense. Second, and perhaps much more important to our subject, is that the state authorities they are not authorized to use their police powers in order to prevent crimes unless inchoate offenders are criminalized, are punishable. We might take as an example the police officer who is watching a person holding a gun and pointing it to someone's head, and he intends to pull the trigger, but nothing could be done at that point, because in a world with no inchoate offenses, since nothing criminal has occurred. Only if inchoate offenses are criminalized, he might take any action in order to prevent the forthcoming homicide. Inchoate offenses function, in fact, in a dual function. First, they function as if they were regular offenses. Second, and much more important to our subject, they function as stages in the course of conduct of the specific offense. In fact, there are three stages. The first is the stage of preparation, which in most legal systems is not punishable. Second comes the criminal attempt. I shall focus on the forthcoming seconds on the criminal attempt, and then I'll gather the rest of the inchoate offenses. And so the second stage is the criminal attempt, which is punishable in most legal systems. And third, finally, comes the stage of the full completion of the specific offense. Demarcating the full completion of the specific offense and the criminal attempt is not considered as a very complicated task, since when all external elements of the specific offense have been existed, it is the full commission. It is the full completion of the specific offense. And when even one of these external elements is missing, it is not more than a criminal attempt. But demarcating the preparation and the criminal attempt is a whole different thing. There are very many tests and sub-tests in very many legal systems that are not very much successfully trying to define the preparation and the criminal attempt. But this has changed. This has changed in the past 10 to 15 years due to the effect of counterterrorism. What exactly happened? Analyzing the terror attacks and the terrorist organizations after the end of the Second World War revealed that the most socially dangerous stage of terrorism, of the course of conduct of terrorism, is in the preparation stage, and not in the criminal attempt or in the full completion of specific offenses which are related to terrorism. At that stage, at that preparatory stage, terrorist organizations are being established. Terrorism is being funded, is financed. Warriors and combatants are being drafted, they are being trained. But all of these actions are not considered as punishable actions, because this is preparation, and preparation is not punishable. Now what can be done? there are two main solutions. The first solution is creation of specific offenses, which are related to terrorism. This solution is not a very successful one, because one must predict very many different situations, and these situations which were now defined as criminal cannot be exercised in a retroactive manner. So the second solution, which is much more successful, is a solution of redefinition of the preparation and the attempt. Due to a Latin maxim of voluntas reputabitur pro facto, which was created in the 2nd century AD by Caesar Adrianus, in the high prosperity time of the Roman Empire dictatorship. And one must wonder why at that point it was created. Now, this maxim says that the will comes for the action. And as a result, preparation and criminal attempt were redefined so that will come for the action. Today, worldwide, preparation and attempt are redefined at that manner. Preparation consists mainly on the criminal plan, what is called in Latin iter criminis, the criminal plan. When people are together planning the forthcoming offense, this is preparation. But this stage ends at a very specific point, when they make their decision to execute the specific offense. From that point on, any conduct which is done due to that iter criminis, due to that criminal plan, it is no longer preparation, but it is criminal attempt, which is punishable. I said any conduct which is done due to the criminal plan, and it was the word conduct was used purposely, since preparation and criminal attempt are considered as criminal derivative liability. And when we speak of criminal derivative liability, conduct have three forms: acts, omissions, and nullity. Professor Fletcher, if I recall correctly, said that criminal law is some kind of a fight between conduct and status offenses, but there is one exception, the derivative liability. So when one does nothing while he has nothing to do, while there is no duty upon him, but it is due to a criminal plan, this is already a criminal attempt, which is punishable. Now, as a result, major parts of the former classic preparation are now redefined as an attempt, and therefore they are punishable. But still, there are major parts of preparation, of the former preparation, which are still preparation. What could be done next? At that point, the counterterrorism law called for another inchoate offense, the criminal conspiracy. Criminal conspiracy has been redefined as a contract between parties. The very gathering of people in order to establish some kind of an offense, it is already a criminal conspiracy. Now, we all know that terrorist activities and terrorist organizations do not act solely in one person. There are more than one person. Therefore, any gathering in order to establish some kind of a terrorist activity is already considered as criminal conspiracy, and therefore it is punishable. But this doesn't end at that point, since counterterrorism law has never limited itself to crimes which are related to terrorism, since terrorism is very difficult to be defined. Therefore, that course of conduct is mutual not only to terrorism, to crimes which are related to terrorism, but also to robbery, theft, homicides, which has nothing to do with terrorism. So the law, the criminal law, became much wider as a result of the effect of counterterrorism law, but not only to offenses which are related to terrorism. What is amazing that in the past 10 to 15 years, it has occurred as a worldwide trend. It was a global trend. Today, when the German court, the Bundesgerichtshof, speaks on the Versuch, and when the French court, La Cour de Cassation, speaks of the l'intentative, and when the English House of Lords and when American courts speaks of the criminal attempt, and when the Israeli court, for the past 10 years, speaks of the ניסיון לדבר עבירה, they speaks on the very same thing. But one must wonder why in the United States not all jurisdictions think as this, at the same kind of thinking, at the same kind of conduct. And I will leave that as an open question. Thank you for your attention, and especially at that kind of hour after lunch. Thank you.
Thank you very much for the clarity and conciseness. It was 2 minutes for the discussion. I open now the floor for discussion, and if anybody has questions, please, Dave.
Abichai, a question for you. You're speaking about economic sanctions to try to force compliance with international humanitarian law. And I'm not so sure why this is connected necessarily to the fight against terror. I could apply it in other contexts as well. And I'd like to know what you would think of the following notion. And perhaps our friends from the ADL could also tell us what they would think of the following notion. Israel, for the last 43 years, has been violating international humanitarian law by putting up settlements in the occupied territories. Would you support economic sanctions against Israel? Because nothing else, even the present American administration, doesn't seem to be able to stop it.
Yeah, I think we have time to take each question. By the time if we see that it's exceeding time, that we will contest it. So we will go one by one. And question is to you.
Let's take your question. I'll answer your question, but first I want to make something clear. If I haven't made it clear, what I was thinking about are sanctions in the context of an armed conflict. Now, to the best of my knowledge, there is no armed conflict between Israel and the United States yet. Meaning that what I was thinking about is when a party has an option between military sanctions and economic sanctions, what are the limitations it has on choosing the path of economic sanctions. This is the first. But I think you are correct in the following sense that, or I'll go into this question from a different angle. A limitation on economic sanctions, unless you do something very, very severe, must assume some background obligation to provide. Meaning, I don't think there is an international obligation on the United States to provide Israel with any assistance. I don't think it's an international obligation. Perhaps it's a political obligation. Hence, I don't think that there is any limitation on the possibility of the United States just to say tomorrow morning, I don't want to do it anymore. It makes no sense to look at it otherwise, since if you think that there are obligations because you just provided it earlier, you can't do, this means that a state that provided earlier is in a worse situation than a state that didn't provide from the beginning. So there has to be some background obligation. Now, regarding Gaza, I assume from different possibilities that there is some background obligation. Regarding civil wars or wars within a state where you have human rights obligation, I do assume that there is some obligation. I don't think the United States has any international law obligation towards Israel in providing anything, and therefore I can see no reason to think why there are any limits at all. on economic sanctions.
I also had a question to reply, so maybe I'll just follow up. I wanted to understand better the connections between the conditions that you propose, because if the economic sanctions are not severe at all, would you be interested in going on and looking into their effectiveness? So, I mean, or would you go on to the other conditions only if it's severe enough? And maybe from another perspective, I mean, I understand the condition of effectiveness, but do you think that courts have the tools to assess effectiveness of sanctions of this sort?
I'll answer one more, but if it goes on, so maybe I'll collect if there are more questions. No, these are different obligations, and the idea, and it's actually, so there was something missing here, but it's in the paper. But here, you have you're doing some derogation from your obligation. You have a human right.
You need to backstop it with something else, because that it certainly could produce the result that in the national security context you could reduce protections essentially to zero if the national security stakes were high enough. That's not so far off from what the Bush administration was doing with regard to aggressive interrogation, and saying that the 5th, 8th, and 14th Amendment protections against harsh treatment really amount to a balancing test. And yeah, if what's at stake is some punitive interest of a prisoner, a common criminal, then there's very little that will accept a state doing that causes some physical pain to a prisoner. On the other hand, if we're talking about preventing 9/11 and the president thinks some action is necessary to head that off, then pretty much anything would go.
Well, in fact, this is a very good question, since it relates to the very basic tensions of the modern criminal law concepts. On one hand, there is the concept of the specific offenses doctrines, which try to broaden the legal social control. And on the other hand, there are the doctrines of the general pop that try to restrict the broadening legal social control. But still, after the effect of counterterrorism law, the offender, the inchoate offender or the full completed offense, the offender who has committed the full completed offense, are subjected still to the general part doctrine, such as the mens rea, the internal elements of the offense, and to certain defenses. And in some kind of sense, nothing has changed. Professor Wayne Lafave, American scholar, said some 20 years ago that we are in a very special era in criminal law. And he called that era as the imperialism of criminal law. Anything should be criminal. Everything is criminal. But still, the restrictions on this wide broadening criminal law are the doctrines of the general parts, which are still relevant.